Is it? Good afternoon, everyone. I feel like we should have potentially got some popcorn. You know, everyone has their coffee and their food and their drinks, so we're ready to start. Welcome to the second edition of this groundbreaking experiment. What if the arbitrator is replaced by AI? I'm delighted to welcome you here to the offices of VIAC, the Vienna International Arbitral Centre, for this special event. Before we get into the topic or start listening to robots, I have a few thoughts on generative AI that I would like to share with you. And I know that any of you who have attended Paris Arbitration Week, or indeed any of the events here at the Vis Moot, you will have listened to many panels focusing on AI, and even panels that didn't focus on AI managed to mention AI. So I think it's safe to say that it is here to stay. It will undoubtedly be the way forward when it comes to drafting, making first drafts, or any source of inspiration for many different projects. Now, I did make the joke yesterday that it's a little bit depressing at a student competition to be saying that AI is the future and is potentially removing the necessity for junior associates. But I think particularly if you look at the quality of the Viz, we know that junior associates and eager and motivated students add a lot of value. But when we look at AI and any new and exciting development, it comes with risks. It comes with risks of confidentiality, comes with risks of data breach, the risk of fake precedents, and questions that were discussed at length yesterday at one of the breakfast events that I attended in relation to disclosure in proceedings. So I'll give you two random examples of how I have used AI in the last couple of weeks, or come across it in the last couple of weeks. We did a number of essay competitions in Central and Eastern Europe as VIAC, because we are also focused on encouraging budding students to get involved in arbitration. And when I went to review some of these essays, I was really impressed by the structure of the essays, the use of the sophisticated language, only to realize that they were actually riddled with inaccuracies. So they were clearly a product of ChatGPT. So that was quite disappointing. Now, I know that any student that's involved in the Vis would never do something like that. So yeah, but that was interesting and disappointing. But on a more positive note, I was organising my daughter's birthday party, and I needed a pony themed treasure hunt, and that I can recommend to all of you. Is ChatGPT is excellent at. And all of the 6-year-olds that partook in the pony treasure hunt would also agree. However, on a less jovial note, I did learn 2 things yesterday from our vice president at VIAC, Franz Schwarz. 2 aspects of generative AI that I consider particularly scary. One is that essentially no one really understands how AI works and how it connects these matrix points together. The second is that the acceleration of capability of AI is so dramatic that the point in time where the processing power reaches or even surpasses human cognitive ability is probably about 5 years. So we have 5 years essentially. But you know, we're in the here and now. So I will move on to introduce you to our arbitral tribunal. None of these individuals really need any introduction, and if they do, you haven't been paying attention all week. I'll start with Cesar Pereira. He is an attorney and arbitrator in Brazil. I have come to know him over the last year as a Brazilian arbitration star. He himself is a former Vis Moot coach and also a moot daddy. Is that a term? I think it is now. Yeah. And then next to Cesar, we have Chris Key and Patrizia Netal. And I'm really not going to introduce you guys because I think everyone knows a lot about you. But I will take this opportunity. I've heard Chris and Patrizia speak a lot this week on behalf of students, on behalf of coaches, on behalf of arbitrators. And I would like to, on the behalf of VIAC and also of the arbitration community, to thank you for the amazing work that you do, the amount of energy, enthusiasm that you put into this to make this really an exceptional competition that I think has touched so many lives for generations. And I know firsthand, because Patrizia is the vice president of VIAC, how much work she does that is not Vis Moot work. So it really is phenomenal. And please, everyone, join me in thanking them for their phenomenal contribution to, I think, the arbitration community as a whole. So I went a little bit off script there. So back to today, maybe when I'm on my thank yous, I'd like to thank you, Cesar, for helping to put this together, and Stella Jo Turner, who is our intern at VIAC, who's there at the back, also for your tireless efforts in making this happen. So let's hope that the tech is our friend today. And last but certainly not least, we also have more stars in the room, which I'm sure many of you will recognize. And when I was introducing myself to the Mooties of the University of Belgrade team, I actually said to them, I watched the final last year on screen. So I feel a bit starstruck. You know, it's like I've seen you on screen performing, and now I'm meeting you in person. So that was the sense I got when I met those guys. So on this side, we have the University of Vienna, and I had the pleasure of meeting you guys on Sunday night. So that was my starstruck moment. We have Antonia and Laurenz, who will be arguing on behalf of claimant from the University of Vienna, the winners of last year's competition. And we have Marko and Fani for the University of Belgrade, the runners up for last year, but certainly winners in every sense. So I think that leaves me to tell you to enjoy the session for the technical expertise.
Thank you very much, Niamh, and thank you for those kind words of introduction. On behalf of myself and Patrizia and Stefan Kroll, who's not here with us, we are excited to be involved in this event. And so in particular, our thanks also to Cesar and the teams for participating. As a moot event, just before I get to the technical side, it is wonderful to be back in VIAC because 25 years ago, this was where the final was held. It wasn't held at the Messe, because we weren't quite as big back then. It was held in this building. So there's been a long association of the Vis right here. My technical briefing is going to be a fairly light technical briefing on my part. I'm going to pass shortly to Cesar to explain to you how things are actually set up in the room. My technical briefing is, I hope, going to be a little bit more thought-provoking rather than informative. So one of the things that I would encourage you all to recognise, and I imagine it's fairly straightforward, but obviously today we are looking at AI as an arbitrator. In the Vis Moot and the Vis Moot rules, you're all dealing with AI and needing to address the consequences of AI as advocates. And I think it is a really important and significant difference to draw between eventually how AI might be used as an advocate versus how AI might be used as an arbitrator. One of the examples that I would give in that regard is that AI predicts. So if you look at the definitions of any of the large language models, so I've got 3 definitions of the different types in front of me here. I won't give you the source because it might be questionable. There's the generic or raw language models, and just they predict the next word based on the language in the training data. And basically that's an information retrieval task. Then there are the instruction-tuned language models, and they are those that are trained to predict responses to instructions given. And then there are the dialogue-tuned language models, and these are the ones that are trained to have a dialogue by predicting the next response. Now, the common word in all those definitions was predict. It is an absolutely fundamental part of being an arbitrator, not that you predict, but that you decide. And so one of the things that is important is when we're thinking about AI and the technical nature of it, you're using a large language model to assist as counsel in terms of predicting the issues that you might need to identify, predicting where the common ground is. Using that sort of analysis, there seems to be a lot of possibility there. But when it comes down to the arbitrator making a decision, it would be a fundamental reversal of our adjudicatory system if we let AI predict an answer rather than an answer being determined or decided by the arbitrator. So you can see I'm a little bit skeptical of arbitrators, of AI as an arbitrator. The other observation that I would make before handing over to Cesar is to ask you to think, perhaps do your moot experience and your preparation for the moot, and to think specifically about the last time you used an online database for research. Think about when you typed in the search terms and the results came back. Most people select the first result to look at. Okay, it's very common to just take the first result. But why was that the first result? Was it the first result because the words that you chose appeared most times in that article? Was it the first result because someone had catalogued the metadata of that article in a way that responded to your search term? Or was it the first response because, and it may be a combination of all these things, was it the first response because everyone had clicked it as a popularity? Like, is there a popularity measure in the response? And if there's a popularity measure in the response, and if it's common human activity to click the first response, we will simply always perpetuate the first response. It will become more and more and more considered relevant by the algorithms involved. Now, what if, when you're looking up a legal issue, it returns an article as the first response and it evolves because everyone clicks on it, and it's espousing a completely incorrect proposition of law? Suddenly, the untruth becomes the truth. And so there is always a need, particularly at this point in time, perhaps not in 5 years, when, as Niamh was indicating, but certainly now, even at the simple level of looking at results from a database, it is absolutely important that you exercise your critical judgment. With all that said, this is an exciting exercise. I'm really looking forward to it. I think it's going to be cool. I've just got to feed in some prompts, which is really good. To explain how that side of it all works, I hand over to Cesar. Thank you.
Thank you, Chris. And first of all, I would really like to thank Niamh, Stella, and the whole VIAC team for hosting us here today. It's wonderful to be able to have this discussion and conducting this experiment in such great premises. And so that's really the first thing I would like to say. You may have heard about something that we did at the Chartered Institute of Arbitrators in Brazil last year, about a year ago, during the Vis Moot season of 2023. We held an online demonstration of ChatGPT as advocate. So we had a human team that had won one of the most important Brazilian pre-moots. So it was a very good team. On the other side, we had two actors, or rather one actor and one political scientist that didn't know anything about law, didn't know anything about the case, and they were prompted by ChatGPT. ChatGPT wrote their pleading. ChatGPT was online during the pleadings, and when the tribunal, which was comprised of David Hübner, Louise Barrington, and Sophie Nappert, when the tribunal asked questions, and they asked questions just like we ask questions in tribunals, in Vis Moot tribunals in general, we would prompt those questions on ChatGPT, and ChatGPT would reply those questions. And at the end, the tribunal was able to assess pretty much how that had gone. And it was a pretty interesting exercise. As Chris mentioned, it's much more related to what probably we will see in the next few years. AI is a supporting tool for advocates rather than a decision maker. But then this year, right after the problem was out, I called Chris, Patrizia, and Stefan and said, look, what do you think about doing something different? We could try to see how ChatGPT would behave as being an arbitrator, not an advocate again. And they really thought that was a good idea and embraced that project. And that's how we came to this experiment now. As you may have heard, we did already something similar to this in Hong Kong during Vis East. What we're going to do here is a little different. And so if you have seen what we did in Hong Kong, it's not the same thing. There are some tweaks that we have done, and also there will be some differences in what we're going to discuss. There is a lot of work that's behind this project, and I would like to recognize and thank the team that's behind this back in Brazil. My partner in my law firm, André Guscov Cardoso, Fernanda Romero, Douglas Amorim. Fernanda is a former Moody, actually my daughter, former Moody. And Douglas Amorim is a computer scientist who has the brains behind this. Leonardo Souza McMurtry and Luisa Quintão. They helped a lot put this all together. And I'd just like to show you, as you can see, this is my screen here. This is the ChatGPT that's here in front of me. We will have two ChatGPTs here. One is called Trinity, with the one which is with me here, and Neo is with Chris. You may get the references, I hope. As you may have seen already, if you have played with ChatGPT, you can create GPTs, which means you can create something that is based on ChatGPT, on this platform, but is customized for some purpose. And what we did was create 2 GPTs, as I said, which are fallen under this category of 30th moot arbitrator. In each GPT has a little difference. The GPT that's here with me received certain instructions about how to act as an arbitrator and the activities that we're supposed to do, and like refer to the facts of the case, the background information that it would have. We gave it some explanations about what the memoranda were and what the case were and how it should evaluate them. The topics for discussion, and we're not going to discuss all of them, as you will see. And then we provided some additional information, and not only the problem in the legal sources, but also some secretariat commentary, some of the memoranda, some advisory council opinions, and things like that. So Arbitrator Trinity has all that information. Arbitrator Neo has received the problem and the legal sources. And so we will be able to tell if and how that makes any difference. As you also may have seen, when the key thing for you to interact with ChatGPT or with any large language model are the prompts. And so it's a funny thing, but we basically have to learn how to ask. It's similar to cross-examining, right? So it depends a lot on how you ask the result that you will get. In artificial intelligence is all about trial and error. So it's expected that you will give a prompt that will not give you the ideal response, but then you can change it a little, and things evolve to get better. What we have here now is already, in a way, the result of some of that. And so Chris and I have a document. You will see some of that document when I do that here on my computer. We have a document with some prompts that will enter to ChatGPT, and that will lead us through the hearing. There is a speech-to-text device here, and so you will be able to hear what the ChatGPTs will say, and ChatGPT will hear the pleaders. For that purpose, and before we continue, before we begin, I would just ask you to be really, as you are now already, be very silent, because that will make a difference for the computer to be able to understand what the pleaders are saying. Okay, so thank you very much for being here. Thank you again, Patrizia, Chris, and Stefan, for all your support, and especially thank you, the pleaders, for being part of this experiment, and for having engaged so enthusiastically with this idea. Thank you.
So starting a session, I would normally introduce you to the panel of arbitrators. In this particular case, I'm not sure how to do it, but let me say my right-wing arbitrator is Neo, and I heard, but I don't know what it will mean, but Neo needs to move around the stage. I heard to be nearer to the microphone or to the box. Yeah. Okay. And to my right, it's Trinity. And I'm not sure how Trinity, Neo, and I will come along with each other, but let's see. We will here in these proceedings, and we agreed with counsel to limit the issues on two. One on the procedure, that is respondents' request on the to stay the proceedings until the investigations against Mr. Fiat have been concluded, or to bifurcate the proceedings. And on the merits, we will hear on respondents' allegation of misrepresentation of the quality of the Kestrel I 2010 drones. And I would immediately hand over to respondents' counsel to start on the issue of procedure.
Madam Chair, just a moment. We just need to do a little prompting to our co-arbitrators here. And so just moving on with our activity here. This is the first prompt, some general instructions about the hearing. So basically what I will do here is...
May I add one instruction?
Sure.
We have an agreement of the parties to limit the submissions to 7 minutes each.
Okay, so this will be the first prompt here.
I'm one prompt ahead.
Well, I don't know what happened with mine here, but now it's okay. Obviously, it was working before you guys arrived here. We'll do the good old reboot. Okay, I'll just put the second prompt as well. So the second prompt is already an indication that what the first activity will be, which is the pleading from the respondent on the first issue. And again, I'm asking it not to interrupt, make any comment, ask any question, give any feedback before I ask her to do it. Now okay, so this is the response to my first prompt, right?
Understood. I will carefully listen to the arguments presented in the pleadings, and once I have heard from both sides on each issue, I will provide my assessment. I will await your instructions to proceed with the analysis of the pleadings, clarification questions, decisions, and specific feedback for each party.
Oh, let's just change this a little here and go back to...
Understood. I will carefully listen to the arguments presented in the pleadings, and once I have heard from both sides on each issue, I will provide my assessment. I will await your instructions to proceed with the analysis of the pleadings, clarification questions, decisions, and specific feedback for each party. I am ready to hear the respondent's argument on the matter. Please proceed when you are ready.
Members of the panel, good afternoon from Equatoriana Geoscience Limited. Sitting next to me is Fani Spalević. She will be arguing the merits of this dispute, and my name is Marko Došlić, and I will speak on the procedural issues today. Before us, conceding that the tribunal has jurisdiction, claimant, or rather respondent, makes an alternative request. The proceedings, namely, should be stayed or alternatively bifurcated until the criminal investigations started against Mr. Field in Equatoriana are concluded. First off, the legal basis for the tribunal staying these proceedings is located in the rules of the Permanent Court of Arbitration's arbitration rules. This is Article 17. It allows the tribunal to conduct the proceedings in a manner it sees fit, and therefore this provides a basis for staying the proceedings. Therefore, the question that arises before us is not whether the stay or bifurcation can be granted, but rather whether it should be granted. When looking whether a stay is warranted, counsel for respondent presents a case law also settled before the Permanent Court of Arbitration, which should be a guidance to this tribunal. Namely, it is the case of Valeri Belakan versus the Kyrgyz Republic, settled by the Permanent Court of Arbitration in 2014. In that case, the tribunal noted that a stay of the proceedings can be warranted where there are concrete indications that evidence of corruption will be found in the investigations. The key difference that needs to be made here is that there does not need to be concrete evidence of corruption. There only need to be indications for a stay to be warranted. Now, looking at these indications, I would first propose a short factual background of the dispute here. What happened in the present dispute is that the Northern Part Development Program was shut down after a regime change in Equatoriana. Following this shutting down of the Northern Part Development Program, Mr. Field, the main negotiator on behalf of respondent, was arrested and he was charged with corruption. He was charged with corruption in regards to 2 other contracts that were concluded under the Northern Part Development Program. So that already is a first indication of corruption. Furthermore, Mr. Blunchley, the main negotiator on behalf of claimant, has also been charged for a white-collar crime, namely private tax evasion. Not only that, it was discovered that Mr. Blunchley had 2 separate offshore accounts with $8 million contained in them. And finally, these 2 people actually came together. They conducted a behind closed doors meeting in a private beach house of Mr. David Field. The result of these negotiations was a highly unusual result. Namely, the purchase and supply agreement is an agreement concluded under a public tender. But in the last round of the negotiation, the scope of the agreement changed, and what was agreed upon for the price of the drones was also changed. Namely, respondent was no longer purchasing 4 drones, it was now purchasing 6, and the maintenance part increased and now formed almost 20% of the purchase price. All of these coupled together form a picture that is hard to ignore, that there is a high possibility of corruption in the present case. Now, why the tribunal should stay these proceedings is because the criminal courts in Equatoriana have a much higher a much better way to investigate this, because the evidentiary powers of the tribunal do not go as far as those of the criminal courts in Equatoriana. Namely, Ms. Fonseca, the public prosecutor that was appointed by respondent in this case, has assured the public that these investigations would be concluded until, or rather in 6 to 7 months, so the delay that would be caused here is also not significant. For all these reasons, staying the proceedings here is the move that the tribunal should make, because the risks of not staying the proceedings and following on with the proceedings highly outweigh the delay that would be caused by staying them. Namely, if the proceedings are not stayed and the tribunal makes its decision here, but later on the criminal courts in Equatoriana uncover corruption that was not identified by the tribunal, it could cause conflicting decisions of the criminal courts and the, now, should I stop? Because I see it's not picking up. Okay, then if the tribunal makes its award and later on corruption is uncovered, we would be running a risk of this award being unenforceable in Equatoriana. Namely, if an award is based on a contract that was obtained through corruption, it could be against the public policy of Equatoriana if the criminal courts later on uncover corruption in that case. However, even if the tribunal finds that a stay is not warranted here, then it should at least bifurcate these proceedings. Namely, it should only rule on the issues that are not affected by corruption and do not depend on whether corruption took place. For all of these reasons, respondent appoints that a stay is warranted. Alternatively, if a stay is not granted, the tribunal should at least bifurcate these proceedings. Now, if I may be of no further assistance to this tribunal, this concludes respondents' submissions on the procedure.
Now, we move to the next prompt, which is a question from the co-arbitrators. So we will include prompt number 3, which asks specifically the ChatGPT to ask a short question about an important issue that requires clarification. So we will both have each one a question, and then the respondent will answer both questions together. Okay.
Neo, like my co-director, has a very sore voice at the moment, and so I'm going to speak on behalf of it. Considering the legal basis presented for a stay under Article 17 of the PCA rules, how does respondent reconcile the need for expediency in arbitration with the potential delay caused by waiting for the conclusion of Mr. Field's criminal investigation?
And Trinity's question is this one. You can probably read it there already. She used to talk. I guess I will read it too. In your submission, you, what? No, it's, I have no idea. In your submission, you reference Article 17 of the PCA arbitration rules as a legal basis for staying proceedings. Can you clarify if Article 17 explicitly contemplates a stay of proceedings in circumstances of concurrent criminal proceedings?
So now I answer both.
Yes, you can answer. We just have to prompt you to so.
Regarding the questions from the panel, first off, whether Article 17 specifically talks about the stay of the proceedings. What is contained in Article 17 is a general obligation, or rather a power of the tribunal to conduct the proceeding in a manner it deems appropriate. Therefore, staying the proceeding is an implied power of the arbitral tribunal. It is not explicitly mentioned. Regarding the second question and the need to observe efficiency of the arbitration process, respondent agrees that efficiency is one of the cornerstones of arbitration. However, the tribunal always needs to strive to render an enforceable award. And where there is risk of unenforceability, efficiency can suffer, or rather the efficiency can be reduced. However, respondent once again appoints that this would only be a delay of 6 months, and therefore it wouldn't endanger the efficiency of the arbitral process.
Okay, thank you. We now move to the next prompt, which is the response from claimant. Actually, it was not supposed to do this. It was supposed to wait. But as you can see, it's very anxious to give its opinion.
I am ready to hear the claimant's argument on the matter. Please proceed when you are ready.
Having some troubles. Yeah. I have to reload everything, I think.
So you see, the technology will have some things to do during the next 5 years to be ready. No, you just reload. You know what?
I know, I've got it back. But it's back, so
Yeah. So if you reload, then you can see that. Okay.
I fear Agent Smith has found his way into our system.
Thank you, honorable members of this arbitral tribunal, and good afternoon, ladies and gentlemen. My name is Laurenz Faber. This is Antonia Hotter, and together we represent Drone Eye PLC, the claimant in these proceedings. Members of the tribunal, having heard the opposing counsel's submission, let me give you an overview of the history of this dispute so far. the respondent concluded a contract with claimant that they then breached when the political situation in Equatoriana changed. When claimant was then forced to initiate the present arbitration, the respondent first objected to the jurisdiction of this arbitral tribunal in an attempt to derail the resolution of the present dispute. When this turned out unsuccessful, respondent now attempts to delay the final resolution of this dispute by requesting a stay or bifurcation of the matter. However, today I will demonstrate that the criminal investigations in Equatoriana do not warrant a stay or bifurcation of the proceedings. And to demonstrate this, I will first introduce an appropriate legal standard for a stay, which is the Cairn test. I will then demonstrate that under this legal standard, the facts of the case cannot warrant a stay or bifurcation of the proceedings, and that the same holds true even under the legal standard advanced by opposing counsel. To begin with the legal standard, my opposing counsel has already directed the arbitral tribunal to Article 17 of the PCA rules. And as inquired by the co-arbitrator Trinity before, indeed the PCA rules do not contain a specific provision on stay or bifurcation. However, as the opposing counsel has rightly pointed out, Article 17 of the PCA rules provides the arbitral tribunal with broad discretion in the conduct of these proceedings. What the opposing counsel has left out is that Article 17 does not provide this discretion without any limitations. Indeed, it foresees that the arbitral tribunal must give the parties a reasonable opportunity of presenting their case. It must uphold the fundamental procedural right to equal treatment, and it must act so as to avoid unnecessary delay and expense. So we can see that Article 17 of the PCA rules already requires certain conditions to be met for a stay to be possible. Going one step further, as the opposing counsel has rightly done, this general standard must be determined more closely by looking at case law in comparable situations. And in this respect, the opposing counsel has pointed the tribunal to the case of Belokon v. Kyrgyzstan and proclaimed that the legal standard would be the need for concrete indications that criminal proceedings would unearth more future evidence. Now, indeed, this was the holding in this case. However, it is important to acknowledge that the Belokon v. Kyrgyzstan award dealt with the issue of stay within only 3 paragraphs of an over 100-page award, not even spanning half a page. And indeed, the tribunal only set out the standard in a letter to the parties saying that they would not accept further requests for a stay if these conditions were not met. Now, let me therefore advance a more appropriate and practically accepted standard for a stay in international arbitration matters. And this follows from the case of Cairn v. India. In the case of Cairn v. India, the arbitral tribunal dealt with the matter of stay not in 3, but in 43 paragraphs of their award, and came to the well-reasoned conclusion that a stay should be warranted if 4 factors are met. In coming to this conclusion, the tribunal highlighted that a stay is an exceptional remedy and I quote, "For it to be granted, the applicant must provide compelling reasons to show that it is warranted." The Cairn test, in essence, requires that the stay does not create an imbalance or material prejudice between the parties, that the stay does not amount to depriving one party from the right to present its case, and that the stay does not delay the proceedings unreasonably, and in the case where the stay is requested in relation to other ongoing proceedings, then the outcome of those proceedings must be material to the outcome of the arbitration. Now, in the case at hand, the Cairn test shows us that a stay or bifurcation cannot be warranted in the present case because multiple of those criteria are not met. Firstly, granting a stay in the present case would indeed create an imbalance between the parties, because then the respondent would effectively have the criminal authorities of Equatoriana working on their side, with extensive investigation powers, as pointed out by the opposing counsel, which would undermine any rules on production of evidence that would usually apply in an arbitration. Furthermore, a stay at this stage would cause material prejudice to our client, because claimant, as a medium-sized manufacturer of drones, is dependent upon the outcome of these proceedings. So staying the arbitration proceedings now could lead to the result that there simply is no drone IPLC left once the final award is rendered. Now, this would be the pinnacle of material prejudice. And in addition, a stay or bifurcation of the proceedings would delay the present proceedings unreasonably, because the opposing counsel has not pointed out which precise findings the criminal investigations could yield that have not already come to light. Indeed, the criminal investigations have now been going on for approximately 21 months and have not unearthed any more evidence than that known already from the case file. So, to wrap up the claimant's submission on the procedural issues of the case, we respectfully ask the tribunal to continue the present arbitration without either stay or bifurcation. Thank you.
Now we will have questions again. And so for that, there will be a similar prompt to the one we did before.
I can read mine if you...
Please do.
Yeah. With apologies for hovering as an arbitrator behind the advocates. Arbitrator Neo is interested to know, considering the standard for a stay you've presented from the Karatube versus Kazakhstan case, could you clarify how the outcome of Mr. Field's criminal investigations would materially affect the resolution of this arbitral dispute?
And Trinity's question is this one. Oh, you see, she only talks when she wants, so I'll have to read this one again. You've mentioned that a stay would create an imbalance and effectively have Ecuadoriana's criminal authorities working for the respondent. Could you elaborate on how this undermines the rules on the production of evidence in arbitration?
Thank you to the Honorable Tribunal for these questions. I will start by addressing the question of Neo on the standard for stay. The case that I advanced was the case of Cairn v. India, but the question holds true all the same. How would the outcome of Mr. Field's investigation materially influence this arbitration? Well, indeed, it is the claimant's position that it would not, because the preponderant part of the criminal investigations against Mr. Field concern other contracts and not the parties' purchase and supply agreement. And indeed, it has not been proven how they would materially affect this arbitration. Therefore, a stay is not warranted. Moving to the question by arbitrator Trinity. In arbitration, there apply rules on evidence production apply depending on what the parties agree on, and there are certain limits to what documents can be produced. Now, of course, such limits are effectively undermined when criminal investigative authorities, which have full powers of inquisition, can conduct dawn raids and collect any documents that they want. So any limits agreed on in terms of document production would be undermined.
Sorry. Now the next step is precisely given that both parties have already made their submissions, and I understand there has been an agreement that there would be no rebuttal or so rebuttal, right? So now we will ask ChatGPT to give a decision considering both submissions and give feedback to both pleaders regarding the procedural aspects. And then later we will do the same concerning the substance. So this is prompt number 6 here. ChatGPT decides on procedure and gives feedback. So let's see how that will go. Not going very well so far.
The case cited, namely Valerie Bellatron versus the claimant argues against a stay or bifurcation, noting the Karen test as the appropriate legal standard. The claimant emphasizes that the outcome of Mr. Field's investigations would not significantly affect the arbitration and that a stay would materially prejudice Drona plc due to the company's reliance on the outcome for its financial stability. Furthermore, the claimant points out that the criminal investigations have been ongoing for a significant duration without yielding new evidence pertinent to the arbitration. Comparatively, the claimant has presented a more compelling argument based on the principle of procedural efficiency and the potential financial impact on their operations. It is crucial for an arbitral tribunal to render a timely and enforceable award. Given that the respondent's claim does not clearly establish the materiality of the criminal investigation's outcome to this arbitration, the request for a stay or bifurcation is not granted. Feedback for the respondent. Positive aspects. The respondent effectively referenced the applicable procedural rules, Article 17, and provided a relevant precedent. The factual background presented by the respondent was clear and laid out the argument for a potential connection between the criminal investigation and the arbitration. Points for improvement. The link between the criminal investigations and the arbitration could have been articulated more concretely to establish the necessity of a stay. The anticipated duration of the criminal investigation was downplayed. More attention to the potential delays and how they could align with arbitral efficiency principles would strengthen the argument. Feedback for the claimant. Positive aspects. The claimant's use of the Karen test was persuasive and appropriate for arguing against a stay by prioritizing arbitration efficiency and rights of the parties. The financial implications for the claimant were well presented, underscoring the urgency and importance of resolving the dispute without delay. Points for improvement. A more detailed analysis of how the criminal proceedings are irrelevant to the arbitration could further fortify the argument against a stay. The claimant could improve by addressing the possibility of the emergence of new evidence in the criminal investigations and why it would still not justify a stay or bifurcation. In conclusion, both parties are commended for their structured arguments and clarity. However, each could benefit from reinforcing their positions with more detailed interconnections between the criminal and arbitral proceedings. The decision aims to uphold the principle of fair and efficient resolution without undue delay, considering the potential impact on the parties' rights and obligations.
Thank you. Arbitrator Neo wrote, after considering the arguments presented by both parties, it is my decision that the proceedings should not be stayed nor bifurcated. The claimant has presented a compelling argument that adheres to the criteria set forth in the CIArb versus Kazakhstan case. They argued effectively that a stay or bifurcation must not create an imbalance between the parties, must not deprive a party of the right to present its case, should not cause unnecessary delay, and that any concurrent proceedings must materially affect the arbitration. The claimant's assertion that these criteria are not met in the present case is persuasive. The respondent's request for a stay or bifurcation appears to be predicated on the potential for criminal investigations yet to yield material evidence relevant to the arbitration. However, the connection between the criminal proceedings against Mr. Field and the specific contractual disputes under arbitration has not been sufficiently established as materially affecting the outcome of the current arbitral dispute. Feedback for the claimant. Positive aspects. Clarity and structure. The claimant's pleading was well structured, providing a clear history and progression of the dispute. Relevance of the law. The application of the CIArb versus Kazakhstan standard was an insightful legal strategy that aligned well with the facts of the case. Points for improvement. Directness. The argument could be enhanced by more directly linking the legal standards to the facts of the case. Anticipation of counter-arguments. While the claimant's pleading was strong, it would benefit from anticipating and addressing potential counter-arguments from the respondent. Feedback for respondent. Positive aspects. Assertiveness. The respondent showed assertiveness in pursuing a stay, signalling a clear strategy. Engagement with the tribunal. The respondent's arguments were framed in a way that actively engaged with the tribunal's discretion. Points for improvement. Evidence correlation. The respondent could improve by providing a more explicit connection between the criminal proceedings and the issues at hand in arbitration. Specification. The respondent's arguments would be stronger if they included more specific details on how the potential findings in Mr. Field's criminal case could impact the arbitral proceedings materially.
All right. So we see that both co-arbitrators found in favor of a claimant. In one thing that we could discuss later, and it has been raised before, if ChatGPT or AI would have like a claimant bias, meaning like, but I don't know if that makes sense or not, especially because respondent went first in this exercise here. But anyway, that's something for us to discuss later. Now we move to the prompts regarding the substance, and we will be ready in a moment to go on.
Yeah, not quite. What do you do?
It's okay. Good afternoon, members of the tribunal, also from my side. To just shortly reintroduce myself, my name is Antonia and I will present the merits of this case on behalf of claimant Dronai plc. Members of the tribunal, respondent is trying to wriggle out of an agreement they themselves concluded. And the reason for that is very simple. The Northern Part development program was shut down, and now respondent no longer needs to purchase drones. So to back out of their obligation, respondent resorts to their domestic law and baselessly accuses our client of fraud. How? By invoking Article 3.2.5 of the Equatorian International Commercial Contract Act, ICCA. However, respondents' attempt to evade a valid contract for pure party political reasons must be declared unsuccessful, and claimant bases the submission on two grounds. First, as the CISG applies to the contract, Article 3.2.5 of the ICCA is not even applicable in the present case. And second, even if it was, our client did not misrepresent the quality of the drones, and certainly not fraudulently. Starting with my first point, Article 3.2.5 is not even applicable in the present case. Rather, the issue at hand is governed by the CISG. And in this respect, it is essential to note that whenever the CISG regulates an issue, it applies exclusively, meaning the CISG supersedes domestic law, such as the ICCA. And with this in mind, let me briefly remind you what the issue is in the present case. Respondent alleges that our client would have first misrepresented the quality of the drones, and second, would have omitted relevant information as to the quality of the drones. And members of the tribunal, the CISG does in fact regulate these exact issues, and it does so in its Article 35, a provision on the conformity of the contractual goods. In short, if a buyer reasonably relies on the seller's misrepresentations, he must then, so the seller, deliver goods conforming with these representations. And if he fails to do so, he becomes liable under Article 35 for non-conformity of the contractual goods. And similarly, as was held by the Swiss Federal Supreme Court in the year 2000, a seller does not have to actively inform the buyer if he is entitled to expect that the buyer concluded a contract in knowledge of all information. Well, respondent in their submission will likely bring in the element of fraud and allege that this would be the distinguishing element between Article 35 and Article 3.2.5 of the ICCA. However, their allegation of fraudulent conduct is not only plucked out of the air, but also the CISG governs cases of fraudulent misrepresentation whenever it relates to the quality of the contractual goods. And this is even supported by recent case law, as was decided by the US District Court Illinois in 2020 in the case Perkins Manufacturing v. Hall All. So, opposing counsel will potentially also try to make you believe that issues of alleged fraudulent misrepresentations are not governed by the CISG by referring you to Article 4 of the CISG, a provision which excludes validity issues. In this respect, I respectfully ask you to keep in mind two very important things. First, the borders of the CISG have to be interpreted autonomously. Just because something might be labeled as an issue of validity under national law does not automatically exclude it from the scope of the CISG. This would lead to enormous inconsistencies when determining the sphere of application of the CISG. And second, as I've already shown you, the CISG regulates all kinds of misrepresentations, no matter whether it was negligent, innocent, or fraudulent. How does it do that? Within its rule of conformity. And yes, fraudulent intent is not a separate requirement under Article 35, but This was a legislative decision by the drafters, and it must not be overridden by applying Article 3.2.5 of the ICCA. And this brings me to my next point. Even if the tribunal decides that this provision is applicable, our client did not misrepresent the quality of the goods, and certainly not fraudulently. In this respect, it is essential to note that respondent bears the burden of proving the opposite. And opposing counsel will have a hard time doing so because the case file just doesn't present any indications or hard facts pointing to fraudulent intent. However, Article 3.2.5 also has a second requirement next to the intent, the misrepresentation of facts. And in this respect, I would like to point out just one simple fact. All of the other bidders participating in the tender process offered drones on the level of Kestrel I 2010. None of them offered Hawkeye quality, even though similar models were still available or were already available on the market at that time, which is evidenced in the case file on page 45 in the paragraph 12. So this serves as a really strong indication that the entire market viewed Kestrel I quality as state-of-the-art and sufficient for what respondents required. So if respondent says that Kestrel I quality is not state-of-the-art, they are basically alleging collective fraud against all of the bidders. With this in mind, claimant respectfully asks the tribunal to deny respondent access to Article 3.2.5 and find that claimant has always represented the quality of the drones correctly. Thank you.
So we will go to the questions now. Chris, if you're ready, Trinity is taking a long time here.
I am, and afterwards I'll explain why Neo is acting a little faster. The question is, Counsel, in relation to the claimant's assertion that the CISG governs all representations about goods quality, can you clarify if the CISG explicitly addresses the seller's obligation to disclose product developments during contract negotiations?
In Trinity has something in the same line here. See if she says something. Still not talking to me. You argue that the CISG exclusively governs issues of misrepresentation. Could you clarify how the CISG's rules on conformity under Article 35 encompass all misrepresentations, including those allegedly fraudulent?
Of course, and thank you for these questions, Mr. and Madam Arbitrator. In fact, the CISG provides for a faultless system of conformity. So the CISG does not provide that fraudulent intent or intent, for example, or negligence is a requirement. However, that does not mean that it doesn't regulate these issues. Rather, it sets out, and this was also recognized in the judgment by the Federal Supreme Court of Switzerland in 2000 in the textile machinery case, that it works with the assumption that whenever a reasonable buyer is entitled to believe that whenever the seller is entitled to believe that the buyer concludes the contract in knowledge of all information, he must not actively inform the buyer of anything. So this regards the omission of facts. And then on the active side, we have that if the seller makes a wrong representation as regards the quality of the goods, this forms part of the contractual obligation. And if the seller then fails to deliver accordingly, he becomes liable under Article 35, so liable for non-conformity. Thank you.
All right, so now we will move to the respondent. And so we will prompt the ChatGPT to hear the respondent and not make any interruptions before we ask. I think mine is mine will require a break. I don't think we can go any further here. Have to rely on you now, Chris. Sorry.
We're ready? Okay. Members of the tribunal, good afternoon on behalf of respondent, Equatoriana Geoscience. My name is Fani Spalević, and I will be representing the respondent on the merits in today's proceedings. We are here today because claimant has fraudulently induced respondent into concluding the purchase and supply agreement. And now, claimant is trying to misuse the CISG in order to protect itself from the consequences of its very own fraudulent actions. Against this backdrop, respondent will make the following submission. Even though the CISG is the law applicable to the agreement as a whole, respondent can nevertheless rely on remedies provided by Article 3.2.5 of the Equatorianian ICCA, which is the International Commercial Contracts Act of Equatoriana. Even though respondent will be addressing the same issues as the opposing counsel, in order to assist this tribunal, the submissions that will be made by respondent will lead this tribunal to a completely different conclusion. Hence, 2 points shall be made. Application of the CISG to the disputed matter. Should I proceed? Yes. Application of the CISG to the disputed matter is preempted by domestic law, and the purchase and supply agreement was obtained through fraudulent misrepresentation. On to the first point. Counsel for claimant has stated that innocent, negligent, and fraudulent misrepresentation are all governed by the CISG. However, the CISG cannot be applied in the present case because under the validity exception of Article 4A of the CISG, fraudulent misrepresentation is excluded from its scope. And that is, members of the tribunal, a uniform doctrinal position, including that of Professor Schwenzer. That opinion states that whenever the buyer has been induced to conclude the contract by fraud, such a validity issue is not governed by the CISG and needs to be resolved by giving the buyer recourse to domestic remedies for fraud. The invalidity of the contract is always governed by the applicable national law, which is, in this case, the law of Equatoriana, or more precisely, Article 3.2.5 of the ICCA. As for the second point, Article 3.2.5 of the ICCA sets 3 conditions that need to be fulfilled in order to constitute fraud: fraudulent conduct or fraudulent non-disclosure, fraudulent intent, and causal link. Pursuant to the call for tender, respondent invited offers for state-of-the-art unmanned aircraft systems, which are based on the newest technology. Claimant has, in turn, offered Kestrel 2010, knowing that it was neither. Claimant was maintaining during the whole negotiation process and even after the signing of the agreement that Kestrel 2010 is a state-of-the-art product and its newest model, as can be seen from the general product information and the sales pitch by claimant's very own COO in the record. In the procedural order number 2, the record states that Hawkeye 2020 indeed was a better product for respondents' purposes. And as it was already mentioned by the opposing counsel, similar technology already existed on the market. Similar aircraft to Hawkeye, which are better for the purposes of respondent than Kestrel I, were on the market, which means that claimant, as a professional and experienced producer of aircraft, knew that Kestrel I 2010 was not a state-of-the-art product, but it still continued to misrepresent it as such. And in addition to misrepresenting the facts, claimant had also failed to disclose relevant information to respondent. Claimant had a duty to disclose on 2 bases. First, being the principle of good faith, and second, being the precedent from the Equatorianian Supreme Court. Since Equatoriana is a common law country, the Equatorianian courts have held that an experienced private party, which is contracting with a newly formed government entity, is under a far-reaching disclosure obligation that needs to cover all information potentially relevant for the government entity. And all conditions for the application of this precedent have been met. Claimant indeed is a private company, respondent is a newly formed government entity, thus claimant had said far-reaching disclosure obligation. Respondent wants to emphasize that courts and tribunals have regularly applied domestic law together with domestic courts precedents when evaluating misrepresentation issues, and that conduct can be seen from various cases, for example, the Window Shades case, Miami Paper v. Lebing case, and Dingsey v. Backwood case. Even though claimant was aware of respondent's needs stated in the call for tender, it knowingly failed to disclose the making of its new and improved state-of-the-art aircraft, Hawkeye 2020. By doing so, claimant acted in a manner contrary to its positive legal obligations. Therefore, the condition of fraudulent conduct set by ICCA has been fulfilled. Regarding the fraudulent intention, it is clear from the record, contrary to the claims of the opposing counsel, that claimant aimed to quell the concerns about possibly outdated technology that has not been updated since 2018 and is never going to be updated again, which is also information from the record. Moreover, it already had 3 Kestrel I aircraft available in stock following the cancellation of its previous order. The condition of causal link is also fulfilled, since respondent was induced to conclude the agreement by claimant's representations of Kestrel I 2010 being a state-of-the-art, newest model aircraft. Otherwise, respondent would never have spent $44 million in order to end up with an outdated technology aircraft. And having in mind that all conditions set by Article 3.2.5 of the ICCA have been met, respondent urges this tribunal to deem the CISG inapplicable to the matter of fraud, since this question is in any case governed by national law. If I may be of no further assistance to the tribunal, this concludes my submission.
Yeah, it's only with you now because I tried to fool the ChatGPT here and it didn't fall for it. Because it seems there is a limit of 3 hours, and since we started working on the rehearsal here before, we spent part of the 3 hours, so I'm sorry for that.
And arbitrator Neo is expressing its views such that I can't put in the next prompt just yet.
You can stop that little square there, and then you just put in the prompt. Chris, actually, what we can do is we can switch, and then you can show your screen, because mine will not show anything. It's just stopped there.
It says, "Oh, the issue is I can't move away from the microphone."
Yeah.
I will.
see your experience in here in witnessing science in the making, right?
It appears arbitrator Neo is now thinking and formulating a question. Given your argument, how does respondent reconcile the application of the ICCA with Article 4 of the CISG, which limits its scope away from issues of contract validity?
Well, thank you for the question, Mr. Arbitrator. That was precisely my point. According to Article 4A of the CSG, the validity of the contract or any of its provision are outside the scope of the CSG, and that was my point. Since fraudulent misrepresentation is a question of validity of the contract, then the CSG is inapplicable to that issue, and we must give the buyer remedies of the national law in accordance with the ICCA.
Thank you. Arbitrator Neo is thinking again. And I will momentarily ask Arbitrator Neo for a ruling. So I'll read as Arbitrator Neo writes. Decision on reliance of Article 3.2.5 ICCA within the CISG framework. After careful consideration of both sides' arguments, my decision is as follows. The CISG does cover general conformity of goods, including the expectation that goods will be of the quality, quantity, and description required by the contract. The respondent's reliance on Article 3.2.5 of the ICCA to claim fraudulent misrepresentation ventures into issues of validity, which indeed are excluded from the CISG scope as per Article 4. However, the CISG does not explicitly address fraud as a ground for avoidance of the contract. While it may cover a wide array of sellers' obligations and remedies for nonconformity, the CISG is silent on fraud, which by many legal systems is considered a matter of validity. In this specific dispute, respondent's claim appears to centre on the claimant's alleged fraudulent misrepresentation of the drone's quality. The CISG, while it does not deal directly with fraud, does handle the expectations set by the seller about the goods. If the respondent expected state-of-the-art technology based on claimant's representations and the drones delivered did not meet this expectation, the CISG could address this under Article 35. However, the respondent's invocation of the ICCA suggests a deeper concern that touches upon issues of fraud, which traditionally are within the purview of domestic law. Feedback for the claimant. Positive aspects. Conciseness and precision. The claimant presented their argument succinctly, focusing on the CISG's governance of quality misrepresentations. Legal reasoning. The argument that the CISG preempts domestic law regarding the conformity of goods was compelling and well-founded. Points for improvement. Depth of CISG application. It would be beneficial to explore the CISG's boundaries in addressing fraudulent misrepresentation further. Engagement with respondents' claims. Directly addressing the respondents' claims regarding fraud could strengthen the claimant's position. Feedback for respondent. Positive aspects. Assertiveness. The respondent was assertive in their claim, presenting a strong argument on why the ICCA should apply. Legal foundation. They provided a solid legal basis for why fraud should be considered a matter of validity falling outside the CISG's scope. Points for improvement. CISG exclusions. Additional clarity on the distinction between fraud and quality misrepresentation within the CISG's framework would enhance the argument. Balance of law and fact. Balancing the legal arguments with specific facts that demonstrate claimants' fraudulent intent would be advantageous.
Well, unfortunately, we will not be able to know what Trinity would decide because, as I explained, we started this exercise a little early, and then I forgot about the 3-hour limit, and I didn't think we were going to reach that. But anyway, so I'm sorry for that. But on the other hand, we have a tool to add here to this discussion, which is the fact that you may have seen at the Vis Moot Center there at Juridicum, this book that was edited by Chris and other authors, Danubio Files 2, which has the human decision on the problem of last year. And so there's a human-made award about the same problem. In the tribunal, in that case, found on the stay of bifurcation of the proceedings, precisely like ChatGPT decided that the tribunal declines to order a stay of bifurcate the proceedings. And on the fraud issue, it found that the contract was entered into as a result of fraudulent misrepresentation. So that can give you some type of comparison with what the results were here. But so the idea of this exercise, and we have reached the end of the prompts, and so we have reached what ChatGPT was able to do with this, is for all of us to have some notion of how this can work in maybe have some type of comparison between the two different GPTs which received different information. And as far as we were able to have both of them working here, at least in my impression was that they had pretty much the same performance. There wasn't really much of a change between one and the other. But that's all up to for us to discuss now. And I would turn to Patrizia, to the chair for her comments.
Yeah, I mean, to answer the question, will the arbitrator replace the human brain? I don't think so after this session. Very soon, at least. Not very soon. I think it gave good indications sometimes of where to point our finger on, but the questions I found often missed actually the real pressing issues to ask. Yeah. They were very much focused purely on the legal, and the links to the factual links, yeah, were actually not considered. And all these questions actually have to be, all these issues have to be decided based on the specific circumstances of the case. And my impression was that the system often was approaching this in a too abstract manner. Yeah, not looking really into the specific circumstances, not really assessing the actual facts. So here I was not truly convinced. And regarding the decisions, yes, I mean, you need to look into the circumstances of the case to make a good decision. Maybe I would have agreed with the first decision, but for different reasons. Regarding the second, I'm not so sure.
Yeah, between this exercise and the one we did in Hong Kong, we tried to change the prompts a little with regard to the feedback and ask specifically about responsiveness. And so to try to make ChatGPT look more into the relationship between the two pleadings and say something about responsiveness. And it actually did not. It performed in that regard exactly the way it had performed in Hong Kong. And it was much, as you were saying, much more based on the allegations of each side individually, rather than in connection with the other, right?
But that even actually led that one question was raised to the wrong counsel. Yeah, I mean, there was one question regarding the effects of the outcome. I mean, you can of course discuss the impact of the criminal investigations with both sides, but that would rather have been a question to respondent. What actually should be the outcome here?
Yeah, and on that point, it seems that the AI is not as strategic as we are in that point, for instance. So and we could see that when we did the other exercise last year, when it answered questions from the tribunal, because it answered questions based on its assessment of what was right or what was not right, not precise, not necessarily what was good or bad for its own client, And so I think I thought when it asked that question that it was asking a question that was actually in favor of the party to which that question was being asked, pretty much because it was sincerely thinking that was a necessary question to ask, regardless of to whom it was asking it.
Cesar, your observation or your comment to everyone then about changing the prompt to want responsiveness did have an interesting impact, which as the pilot of NEO I can describe. Respondent should most certainly appeal the in whatever manner and form it can not appeal, but take some action, because the entirety of their submission with respect to procedure was lost. And so the decision was only made on the claimant's submissions. And I think it's interesting, and I don't know if others noticed it at the time, but when the decisions were read, Trinity's decision provided the observations and feedback to the respondent first and then to the claimant, whereas NEO provided feedback to the claimant and then must have entirely hallucinated the respondent's submissions. And so the feedback to the respondent was based on nothing.
Yeah, I was hoping when I was trying here to make it work after it blocked, I was hoping that I would get a clear chat, ask for a decision, and have exactly that, a decision made out of nowhere, right? Out of nothing, because basically, and that's a very important point when we're dealing with large language models. It not only predicts something, it basically tells you what you want to hear. It's a seductive liar, right? It will just say what it thinks that will sound good as the next word in a sequence. And so I think we have to be very mindful that those are all very important technologies, and they are growing. They have a lot of potential. And again, we are dealing with here. We are dealing with an off-the-shelf system that even when it's paid, like this one is, it's paid $20 a month. So it's very cheap, and so this is something that anybody can use, right? It's not sophisticated system that's customized for a global law firm or organization. And so we can imagine what professional speech-to-text system plus sophisticated AI would be able to do, which is much more than what we did here today. But we can, I think it's fascinating to see how it can structure an argument, how it can sound persuasive, how much it can be lying, and we don't know about it. And but those I think are really fascinating things. But I was really curious to hear from you, from the Moody's, and how you thought this was this went, and you had the experience of having human arbitrators last year, and of course your pleadings were at a level that that's embarrassing for ChatGPT, right? ChatGPT was much lower in level considering your pleadings. But how do you? What is your reaction to the questions that you're asked, or to your feedback, or to the whole experience? Anybody?
Well, I agree that arbitrators are not going to be replaced anytime soon. But I liked the feedback, actually. Maybe it was a bit generic sometimes, but it did pick up on some points. I didn't quite get my question. Did ChatGPT just like ask me, is that your submission? Basically, just restated my argument. Yeah, I wish that arbitrators did that too.
Yeah, likewise for me. First of all, I agree with what was already said. It sort of only picks up the legal basis that you're using. And if I mention Article 17 and then talk 7 minutes about everything else, it's only going to ask about Article 17 and something that's not even that disputed. But then what was also interesting for me is that when Laurenz brought up a case, it took that test, but it can't check whether the case exists, I suppose. So it's a made-up case name, it's a test, but it's fine for it. So I don't know how that can be circumvented in the future, but I don't know if it's ever going to be able to like look at all of the case law that's available and then say this doesn't exist or this does exist. But
yeah, I think I've never had an arbitrator that interested in the concept of conformity of the CISG before. So usually the questions from arbitrators would be about facts, and they would, hurt you with the things you let out or you didn't reveal in your pleading. But I was really surprised how bad, the speech to text worked when I was looking at it. And then it turned out pretty well in the end, and you could give sensible feedback, but it's probably because part of it was made up. Yeah.
Yeah, I can only concur with what's already been said by everyone, basically. So I also observed that the questions were rather basic as compared to human arbitrators, who tend to be quite sharp. And they were really a gift to the pleaders, I would say, because it gave you an opportunity to restate your argument and make it even stronger than before. And what Marko pointed out rightly, it seemed to have a possibility to really check sources as of now. I know that there are large language models which already have access to Google and the documents available there. So it would have had access to investment arbitration cases, but we all saw that it mislabeled my case entirely, but still